All right, hi, welcome back. Attorney Steve Honor. Welcome to another exciting video. Thank you for watching today. Today we are talking about fair use opinion letters, fair use opinions, and fair use in general. Okay, so without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, so our firm handles a lot of what we call fair use opinion letters. And mainly this is for like documentary filmmakers and podcasters, people that want to use third-party creative content, not their own content, in their videos. So I've got my little video editor up here so you can kind of visualize what we're talking about. But we do fair use opinions, and this basically involves wanting to use third-party content here. And a matter of fact, before I start, let me read you the fair use rules so you understand. Now you can find this in 17 USC 107. I've got it up there on the board, but I'm going to read it to you real quick, okay? So 17 USC says, fair use, the Copyright Act provides a defense to infringement for fair use, 17 USC 107, and provides that a use is non-infringing if it is for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. This is not an infringement of copyright. 17 USC 107, okay? So that's your general, what we call the black letter law, and that's your general rule, okay? So you may be using any of these different types of third-party content, video clips, music clips, sound effects, photos, book quotes, all kinds of creative content. So many things can be subject to copyright, even like jewelry and computer fonts can be subject to copyright. So, but you want to make sure that you're using it properly so you don't end up in court. Okay, so just to set the record straight here, it's a statutory right. I just read it to you, right? But when you get into court, it's an affirmative defense. And so what does that mean for my law students, paralegals, other lawyers? It means affirmative defense, raise it or waive it. And you as the defendant, if you get sued for copyright infringement, then you're going to have the burden of proof. And really what we look at, it's a 4-factor test. I'm not going to go into it here. I believe I have a blog. I'll put a link down in the message area. I'll put a link to the 4 factors so you can check it out. But this creative content, you want to use it in your project because you want to use it to help tell a story. Usually that's what we're dealing with. I deal with documentary filmmakers. We just did Al LaBelle, mentally ill comedian, just hilarious guy. I posted that on my thing if you want to see. But we do fair use opinions for filmmakers and things like that, documentarians. So, but I want to go over a couple things where it's okay to use third-party content, where you can use it, no problem. One, get permission. You find an artist, maybe it's you want to use some music. You go to the publisher, you go to the master rights holder, and you say, I need to use this song to help tell my story. It's the greatest story ever told. And you get permission, you get a license, you get an agreement. Okay, sounds good, go for it. So that really touches on permission, which is essentially a license, okay? Now, another way that you can get third-party content into your project is public domain. I've got that here, public domain. So copyrights don't last forever. So let's just say you go back to the 1800s, you find a video, a picture or something you want to use, okay, old book clip or whatever, and you want to use that. That's probably in the public domain. I mean, if you're looking that far back, copyrights don't last forever. That's probably public domain, but it gets a little tricky. I'm going to do a separate video on copyright duration. It's a little bit complicated, so I'm going to do a whole separate video on that. But just realize public domain is available, free to use, no charge. And finally, I want to talk about Creative Commons, okay? And I have fair use, of course. If it's subject to fair use, it's free to use. But Creative Commons, here's another one. You got to be careful on this one because you go to search engines and you may find something that says, free for use, free for licensing. Let me tell you, there are photo trolls out there, in particular photo trolls, okay? And they will give things away. They'll say, free, it's Creative Commons, it's all free. And you go, wow, this is neat, but you don't follow their rules. They can put particular rules on their usage. Like, I want you can use it. And then in the small print, it says non-commercial use only. or it says must link back and provide a link to my email address and a link to my website, and you must put down my birth date and social security and everything. Or so if you don't follow the rules exactly, they can sue you for copyright infringement. And I see this. There are photo trolls, I'm not going to name names, that play these little games over here with Creative Commons. I have a separate video on Creative Commons I'm going to put down in the message description area. If you haven't seen it, you don't know what Creative Commons is, you want to use Creative Commons material, make sure to watch that video, okay? So that's Creative Commons. Now I'm going to talk real quick about some of the myths. The myths. Can you say that word? Myths. Myths of copyright law. These are the top 5 that I see pop up all the time. Common misconceptions. Number 1, okay, so people think attribution alone will save the day. In other words, I'm going to use a photo in my video, and I'm going to say on the end of my movie, I'm going to say, thanks for the photo. Thank you, Walt Disney Photos. Thank you. Attribution. That alone is not going to save you. That alone does not give you fair use. You could still end up being sued for that, depending on how much you used and everything else. So attribution alone doesn't get you there. I see this in photo infringement cases sometimes. Well, I posted the artist's photo, but I said how much I like him, and I gave a link to his website. Yeah, they're still going to come at you and try to get a couple $1,000s out of photo infringement. Trust me, we'd handle a lot of those cases. So that alone is not working. Duration, time limits. Some people say, well, if it's under 30 seconds, it's good. If I'm just using a 30-second song clip, what's the big deal? I mean, that's just not even the whole song. That's not true. If you say, well, I'm only using a 3-second sound effect, that's not true. Not necessarily true, okay? So you still have to be careful. So there's no hard and fast rule on how many seconds you can use, okay? There's no hard and fast rule. When we're doing a fair use opinion letter, a fair use analysis, we're looking at all the third-party content. We're running it through our 4-factor test, and we're deciding, would this qualify for fair use? Will this clip qualify for fair use? Will this book quote that they're using, will that qualify for fair use? I'll talk about right of publicity in a second. That's a separate issue. But basically, there is no hard and fast rule on time, so we've got to look at the 4 factors. Disclaimers, this is another important video that I did. I'm going to put it down in the message area, just the treasure trove of information here today. But a disclaimer, and I like disclaimers, okay? And this is where you put on the beginning of your video or the end of your video, or sometimes in the message area, description area of your video, you put a disclaimer that I'm using things under the fair use doctrine under 17 U.S.C. 107, which is a federal law. It's a federal law in the United States, okay? Most countries have their own version of this. Canada calls it fair dealing, okay? So, but you put in a disclaimer, you just let the potential copyright holder, the holder of the copyright, you just let them know, hey, I'm just using just enough to tell my story, just enough to tell my story. So as we like to say, as I like to say to my clients, use the minimum necessary third-party content that you need to tell your story. That you gotta have this. It's gotta be 8-second clip. It's just if it's 7, it just doesn't tell the story the same way. That's what you're looking for, the absolute minimum third-party content necessary to tell your story. But a disclaimer is good. Put it on there. Let everybody know that you are claiming some fair use rights. It's not mandatory. You don't have to do it. It's not mandatory. A lot of people like to use that, and I like it. Okay. But a common myth is that alone does not make it fair use. Okay. Non-commercial use. Here's another one I get a lot. I use their song, but it's only on my YouTube channel. I say, well, do you monetize your channel? Well, what do you mean? You monetize the video? You can go into each video that you post, and you can choose whether you want to monetize it or not. You're monetizing the video? Yeah, I guess. Yeah. Well, people consider that to be a commercial use. So again, whether or not something is commercial in nature or non-commercial, nonprofit, that is one of the 4 factors. And I'm not going to go into the 4 factors today, but that's one of the 4 factors, not determinative either way. So again, just to say, well, it's non-commercial and I wasn't making any money, it was a personal blog. Yeah, rights holders tend not to go after that if it's completely non-commercial, but it doesn't mean for sure, okay? And parody, final myth, is some people will say, well, I used that video in parody. I was just doing a parody of them. Well, you can do a parody. Remember this, a parody has to poke fun of the original work. Okay, so if you're going to use a video, you have to be making fun of that video. If you're using content, you got to be making fun of that content. You can't use somebody's material to create satire. I mean, generally, this is all generally speaking. This is not legal advice. General legal information only, but you can't use it for satire. You have a very lesser degree of an argument that a satire would qualify for a fair use. So parody, make fun at the original. As we used to say in law school, parody is like shooting at the king. You better not miss. All right, so there's your common myths. There's your common ways to get it. Some of the penalties. You guys probably already know this. Penalties, somebody can come on and jump on your video and monetize your video. That's no fun. You want to make some money on your videos. But that may not be the worst. The worst is takedown. Somebody can try to take down your videos, get you strike 3, and you're out on YouTube. So you got to be careful about that. And then I want to tell you just the last thing. This is last thing. Actually, right of publicity is going to be the last thing. But small claims court's coming in Washington, D.C. And you should know this. If you're a creator, you need to be very careful about fair use now, because there is a court, it's actually a claims board, copyright claims board in the registrar's office, copyright in Washington, D.C. The claims can go, it's called small claims copyright. It can go up to $30,000. So if you're using somebody's video clip and you can't qualify here, or you got your 4-factor test wrong here, you're using their music clips, photos, this, that, and the other, you can find yourself in copyright small claims court in Washington, D.C. Mostly this is going to be digital from what I understand. But I'll put some information down in my message box. I did some information on the small claims court. It's up to $30,000. You know, that's not small claims to me. That's big bucks, you know, up to $30,000. So you have to be very careful nowadays being a creator. I think more is going to be expected of creators as we go through, as we're learning more about copyright and Creative Commons and public domain and disclaimers, and you know, everybody's becoming a creator now. So anyway, that's something to keep in mind. And last thing I'm going to say is right of publicity. Just being careful what you're using in your videos, models and actors. Third parties, are you commercializing somebody, making them the main focus of a clip, the main focus, maybe predominant in your film? You got to be careful. There is such thing called right of publicity. Let's give you an example. California, name, image, likeness, signature, things like that. Your voice can be subject to right of publicity. Even dead people in California have a right of publicity that goes 70 years after their death. 70 years. It goes to the heirs. The heirs have the rights to exploit that. Okay, so if you need some more information, call us on the rights of heirs. But this can lead to California right of publicity cases. We've handled a good number of those cases, and they can be very big cases. They do have attorney fee possibilities and things like that. So be careful when you're using these rights. Of course, there are some exceptions. Somebody says, I want to sue you for a right of publicity. There are some exceptions, First Amendment, newsworthiness, public affairs, things like that. So there are some defenses, but sometimes you want to be thinking about getting life rights or getting someone to help say, here's the scrapbook. You're going to make a documentary on this guy. Great. We're the family. We'll open up the scrapbook for you. Wouldn't that be nice? So anyway, this is a general look, not legal information, general look at fair use opinions. We do them. They're based on how much we have to review, how much material, how many third-party clips that you have. But call us if you need a quote. You can find us on the web at attorneysteve.com. That's attorneysteve.com. So we have flat rate fees for most of our fair use opinions. So give us a ring. We're happy to take a look at your project, okay? Hope this has been helpful. If you like it, subscribe, punch that like button, and go ahead and share the video. We're fine with that. Have a great day now. Attorney Steve out. Got to run. Bye.